case briefs, and so much more. LSData's got what you're looking for.
In 2009, a significant case grappled with the boundaries of Fourth Amendment rights in the United States Court of Appeals for the Third Circuit. The primary question was whether law enforcement needed proper permission or solid grounds for conducting a house search. Also hanging in the balance was whether evidence unearthed independently of an unjust search might still stand in court. The case of United States v. Price was spurred on its way to court when John Joseph Price, Jr., was found guilty of manufacturing and possessing methamphetamine following a search of his premises. Price protested the verdict, arguing that his Fourth Amendment rights, which protect citizens from unreasonable searches and seizures, had been infringed upon. Price also contended that the government should have lessened his sentence. However, the court deemed the search voluntary and saw no reason to adjust his punishment. Price pleaded guilty but preserved his right to contest certain elements of the suppression motion on appeal. Evidence obtained during the law search was subsequently deemed admissible. This series of events started on April 5, 2002, when Price sold methamphetamine to an undercover agent, which culminated in his arrest in October 2004. The verdict of the lower court to suppress evidence and calculate the sentence was upheld by the Court of Appeals. The court ruling affirmed the legality of the search warrant and the admissibility of the evidence against the accused. Price chose to waive his bid for sentence reduction. The court ruled that endorsing the waiver did not result in any miscarriage of justice, thus bringing the saga of United States v. Price to its lawful conclusion.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.